BingX, a trusted global crypto exchange. Trade spot, futures, or copy top traders easily. Sign up via the link or referral code to get 30 USDT instantly, plus up to 1,500 USDT in bonuses for verification, deposit, and trading.
The Australian government has firmly rejected a controversial proposal that would have granted technology giants unfettered access to copyrighted creative content for training artificial intelligence models. This decisive stance, announced following a robust outcry from authors, artists, and media organizations, signals a significant victory for intellectual property rights and the nation's creative sector. Attorney General Michelle Rowland is set to officially confirm the decision, effectively closing the door on a contentious suggestion initially floated by the Productivity Commission and actively supported by major tech players. Rowland emphasized the vital role of Australian creatives, stating they are not only world-class but also the very lifeblood of Australian culture, necessitating the implementation of robust legal protections. The Productivity Commission's interim report, focused on harnessing data and the digital economy, had ignited widespread outrage in August by recommending an exemption to copyright laws. This exemption would have broadly permitted technology companies to freely utilize creative works for AI development, a move many viewed as a blueprint for widespread appropriation. Earlier, Scott Farquhar, co-founder of software giant Atlassian and chair of the Tech Council of Australia, had advocated for fixing existing copyright restrictions, suggesting it could unlock billions in foreign investment for the country. However, this push was met with formidable resistance from the creative community. Acclaimed First Nations rapper Adam Briggs, testifying before a parliamentary inquiry, powerfully articulated the concern that once such access is granted without fair compensation, it would be exceedingly difficult to get the genie back in the bottle. Renowned author Anna Funder echoed these sentiments, describing the large-scale AI systems as being built upon the wholesale, unauthorized appropriation of every available book, work of art and piece of performance that can be rendered digital, a stark characterization of what many perceive as brazen theft. Adding to the controversy, the Productivity Commission later revealed that it had not consulted with creatives or thoroughly modeled the impact of its recommendation before its publication. This disclosure prompted Greens Senator Sarah Hanson-Young to declare that the government agency had fundamentally misread the value of the creative industry. The Australian Council of Trade Unions also sounded a grave warning, cautioning that the proposal would pave the way for rampant theft of creative endeavors. While senior government ministers had previously downplayed the likelihood of approving a text and data mining exemption, Rowland's explicit ruling marks the first unequivocal rejection of the idea. The Attorney General acknowledged the immense potential of artificial intelligence for Australia's economy, but underscored the critical importance of ensuring that Australian creatives also share in these burgeoning opportunities. In the coming days, Rowland will convene the government's Copyright and AI Reference Group to explore alternative strategies for navigating the evolving technological landscape. Discussions are expected to include the potential establishment of a new paid licensing framework under the Copyright Act, which would replace the current voluntary arrangements. The Australian Recording Industry Association, ARIA, a key campaigner against the proposed exemption, hailed the government's decision as a critical step in the right direction. ARIA Chief Executive, Annabelle Hurd, declared it a win for creativity, Australian culture, and common sense, asserting that existing copyright licensing structures are foundational to the creative, digital, and technology economies. She emphasized that intellectual property laws are precisely what tech companies rely upon to safeguard and monetize their own innovations, thereby driving further progress. Hurd further stressed the need for additional measures to protect artists, including ensuring that licensing rules are uniformly applied to AI development. She passionately argued that artists must retain the fundamental right to dictate how their work is utilized and to benefit financially from the value it generates, asserting that safeguarding this agency is paramount to preserving Australia's creative sovereignty and cultural vitality. Media organizations have also voiced their approval of the government's decisive action. A spokesperson for Guardian Australia described it as a positive step towards recognizing that Australian copyrighted content deserves protection and payment. The spokesperson highlighted that Australia's media, publishers, and creatives had collectively opposed text and data mining exceptions, warning that such provisions would essentially sanction the large-scale pilfering of work by Australian journalists and creatives, acting contrary to the nation's best interests. The Guardian is advocating for the development of a fair licensing regime that fosters genuine value exchange. Michael Miller, Executive Chair of News Corp Australasia, concurred, labeling the government's decision to reject the exemption as the correct one. He asserted that, by upholding creators' rights to control access, terms of use, and compensation, the government has reinforced the efficacy of Australia's copyright law in ensuring sound market outcomes. The overarching sentiment is that while artificial intelligence offers exciting prospects, its advancement must not come at the expense of creators' fundamental rights and the integrity of intellectual property, ensuring a balanced approach that fosters both innovation and cultural preservation.